And good morning. Let me start by saying thanks to Todd Beardsley and conference organizers for inviting me out to talk to you today. This is sort of an unusual talk. I've done this a couple of times at different conferences, and it obviously is going to be different than the talks you've heard in the last few minutes. So this is kind of the product of something that happened 2 years ago. Some, I think, somewhat brave hackers wandered into our offices in DC. I'm from the Computer Crime and Intellectual Property section of the Department of Justice, and they had a message. It was, your ways are strange to us and kind of scary, but we believe that what you do is chilling legitimate research that would help protect networks. And our response to them, I think, surprised them, and it was, that's a problem, maybe we should fix that. So that started out a set of interactions where I flew out to Black Hat that year, met with a room of researchers where there was an airing of grievances. Returned the next year to give a presentation along the lines of the ones I'm going to give this morning. And just last month, I moderated a panel of white hat hackers at our annual conference of about 250 of the prosecutors across the country who prosecute cases like this, with the intent of having folks explain, here's what we do, here's why we do it, and here's why it's valuable. So this is a set of ongoing engagements that the Department of Justice is looking to do to make sure that the security ecosystem is as robust as possible, and that important players like you guys who are finding vulnerabilities and making sure we know about them are not doing that because of fear that the law will apply to them. So with that in mind, we have a lot of ground to cover, and let me say that if we don't get to certain things or if there are questions that you have later, I will be hanging around, so feel free to approach me then. So here's what the plan is. First, I'd like to give you a tree skimming view of what it is we do at the Department of Justice in this area, what the Computer Fraud and Abuse Act, which is one of the statutes that people have voiced most concern about, how that applies to criminal behavior generally, how we've used the statute, how many cases we bring, what are the sentences that result, and provide you at the end with a few thoughts about how maybe as researchers you can avoid hassles with law enforcement. So with that in mind, let's start. Who prosecutes hacking crimes? So this is kind of a Schoolhouse Rock type of slide where we're just explaining that you've got the states who have about 56 different attorney generals who apply state law, and at this point almost every single state has a computer hacking statute. In contrast, on the federal side, you have what I do. I work for the Attorney General of the United States, and we have one set of laws, federal laws. The reason I mention this is, since we started these engagements, I've gotten calls every so often. Last year, got a call saying, in Holiday, Florida, there was this middle schooler who shoulder surfed his teacher's password and changed his wallpaper and was charged with a felony. Really, guys? Really? Something similar happened in Orange, New Jersey, in Southern California, I think it was in October. And my response is always the same. Without discussing the merits of those cases, that wasn't us. For reasons that I'll get to, our cases tend to be larger and more substantial because we don't have, the resources to go after everyone, so we have to prioritize. So I only raise that to say that sometimes when you hear about a case that's being prosecuted, it is not always us. There's some chance that it's also the state authorities. So who are we? So I'm from Washington, D.C., as I said. We have a network of prosecutors across the country in the 94 districts who are specialized in cybercrime. I'm from the Computer Crime and Intellectual Property section, which supports and trains those prosecutors. And they're taught how to handle these cases, new technology trends, new trends in criminal law that are applicable to this area. And just last year, we did something new. We created a cybersecurity unit. The purpose of that is, while we are by trade knuckle-dragging prosecutors, we also can apply that knowledge to figure out how we can prevent cybercrime. And so we're trying to, for example, like this, provide guidance to people who are engaged in security work so that they know when they can and can't do things. Again, we want to encourage legitimate research. We also want to make sure that people know what are some red lines that they shouldn't cross. So, let's start with what is the CFAA, the Computer Fraud and Abuse Act? It's not actually one thing, it's 9 different offenses. However, today, given the time and everything, I'm going to focus on the one provision that is most likely to apply to you, and that's the 1030A2 provision, which is accessing a computer and obtaining information without authorization. So what does that mean? Let's break it down. So this is actually what the text of the law says: to intentionally access a computer without authorization or exceeding authorized access and obtaining information. So what does that all mean? Let's start with the intentional access portion. Under criminal law, there are different mental states that are required. The lowest being generally knowingly, or you just know that you're engaged in a certain activity. This is intended to be something more than that, so people don't blunder into it. It's intentionally, so you have to intentionally engage in the activity that is being criminalized. It has to involve a computer. Now, the Act defines a computer very broadly, but this particular revision focuses on 3 types of computers. The first being a computer belonging to a financial institution, which isn't surprising because that's where criminals tend to focus a lot of their activity if they're interested in money. Or a government computer. At the time when this statute was actually enacted, 1984, revised in 1986, that was one of the big concerns, people breaking into government systems. So it's not surprising that would also be included. But most importantly, any protected computer, which is a defined term under the statute, is also covered. What's a protected computer? Well, it essentially is anything connected to the internet, and that's why this is important. So if it's a computer that affects interstate commerce, and for us lawyers that means essentially anything that is in the flow of commerce, again, anything that's connected to the internet, is going to be reachable under this statute. You have to obtain information. Does that mean you have to exfiltrate it or download it? Not necessarily. If you remote into a system and look at the directory structure, you have obtained some information about that system, so that might apply. Now the interesting part. Without authorization or exceeds authorization, you may say all these other things we've talked about are things that anyone could engage in, could kind of, I mean, every day people actually access computers in that way. Well, this is the part that is intended to sort of weed out the innocent from those people who were intended on doing something malicious. And how well it works has been the subject of some debate on the Hill and in the public. Now, in the vast majority of instances, this is an easy call for us. You've got someone who is looking to steal credit card information, monetize that in the black market, and is engaged in criminal activity without any question. In the alternative, you also have those random sysadmins who were just fired, who decided they're going to return to work or remote into work after they've been let go and take documents, wreak some havoc, and be done with it. Again, clearly not lawful and clearly something that's prohibited by the statute. What's come up in the last few years, though, is a concern that something that is far more marginal. So let's say you have an interaction with a website that has a terms of service that prohibits certain types of conduct. So you're on Match.com and you decide, I'm going to talk myself up a little bit more, maybe not consistent with the terms of service. Is that a federal violation? I've done that. Or in the alternative, I'm at work. There's some employment agreement that I will only use this for no personal reasons, and I check the ball scores. Am I now guilty of a federal violation? Now, this largely would not be something anyone would be concerned about if not for one case. In 2008, there was a federal prosecution related to a particular matter that made some national news. Lori Drew was the mother of a child who decided to tease a kid at school in Missouri. And together, they created a fake identity on MySpace and engaged in communications with that other girl, flirted with her, befriended her, and ultimately dumped her and goaded her into suicide. The Missouri authorities concluded that there was no actionable activity under their statutes. So the U.S. Attorney in the Northern District of California, where the MySpace servers were located, decided that he would try to make a prosecution out of the case. And the theory was that the creation of this fake ID was contrary to the terms of service. There was a conviction. That conviction was overturned, and there was a lot of concern with the theory that supplying false information to create an account was now actionable under 1030. Again, the Court of Appeals overturned that conviction, and the department didn't appeal, and we've not sought to bring another case of that sort since the 2008 case was initially brought. So all of this falls into the area of the exercise of prosecutorial discretion. And I imagine that you, sitting here, have a similar concern as a computer security researcher, which is what that icon, the happy guy, is intended to reflect, that you have a concern about your conduct possibly tripping over the same issues potentially. Now, hearing this, in the last couple of years, we started to work on how we might narrow the legislation so that we can still go after the bad guys we need to go after, but weed out some of the conduct that is trivial and should not be actionable. So one of the amendments we floated last year was an amendment to require that it not be any information that be obtained, but rather information that is in furtherance of a separate, unrelated felony, like the credit card cases, information stored on a government computer, which was already still part of the statute, or information worth more than $5,000. Now, I have to say on this last element, we may have to give that some more thought, because this was not created with the notion of things like the vulnerability and exploit market. It was a notion that the information itself was worth $5,000. It's possible we may have to think that through a little further now that we've talked to people more about things like the vulnerability and exploit market and how pricing might work with that. But the punchline here is we're trying to figure out how to appropriately tailor the statute so that we're only going after conduct that really warrants going after. Now, since we don't have an amended statute, I thought it might be worth talking about, so how are we today actually using the statute? Pulling this data is publicly available. It's from the U.S. Attorney's Office's annual report, which is online. We know that there were slightly less than 55,000 cases brought in the federal system last year. Of those cases, not surprisingly, a lot of these, the lion's share, were in areas you'd expect: violent crime, narcotics, immigration violations. In addition, about 1/10 were white-collar offenses. And then we come to the computer fraud and abuse claims, which totaled about 153 last year, which wasn't out of the ordinary for the last 5 years or so. They tend to hover somewhere in the mid-150s. So roughly 0.2% of all of the cases were computer fraud and abuse cases. That might lead to the next question, which is, so can you tell us how many computer security researchers were also prosecuted there? And that wasn't easy, because we don't keep numbers in that way. We don't tally by the identity of the defendant. But what we did was we put out a call to our network of prosecutors across the country and said, for the last 5 years, can you send us any cases, identify any cases in which a computer security researcher who was engaged in research was the subject of a prosecution? And what came back was fewer than a handful of cases, and those were rather generous in that. I think actually a single one of those cases, which is quite notorious, was the one that legitimately was someone who was engaged in what would be called computer security researcher, and that was the Spittler-Arnheimer case. And so at the end of the day, you ended up with something in the area of 0.2% of all computer fraud and abuse cases, which are 0.2% of all federal cases touching on computer security research. So moving beyond that, all right, so how do you charge cases? Maybe that would also provide you with a little bit of understanding as to where we put our emphasis and why we have certain cases. So there was a directive put out to our prosecutors 2 years ago or so that was intended to further discipline how people bring these cases. And it requires the prosecutor to raise the following question: is this matter, specifically under the CFA, going to advance a substantial federal interest? Provide some further context to that, and provide some criteria by which you would try to judge that. So, you know, what is the nature of the resulting harm? Is it significant enough? Which often is connected to who the victim is. So, for example, in instances where you're dealing with a victim who It's a company that is holding a lot of consumer data. We're going to be very interested in prosecuting that case and getting to the offender because we protect a lot of people's interests by doing so. Sensitivity of data. Whether it is itself sensitive information, we deal with sometimes companies who say, my intellectual property was stolen, and if that gets out, it will destroy my company. Well, certainly we care a lot about that and would want to work on such a case. If it supports larger criminal activity. So we do a lot of work that involves transnational organized crime, and these organizations are leveraging different pools of criminal activity to make money to further other criminal activity. That is something we care about again. Harm to national security and public safety. You may have heard recently there was an indictment 2 weeks ago of, for example, what is alleged to be Iranian hackers into dams in New York. You've heard other cases where there's been targeting of military personnel for doxing. So those are things that obviously we are going to prioritize. And lastly, deterrence. Sometimes there is a new strand of crime, a new type of criminal behavior that we think probably warrants some statement in that we will prosecute a case so that people understand that that's conduct that is actually in fact illegal. Now, when we do get to prosecution, and the reason why I'd like to talk about this is there is concern that has been expressed that perhaps prosecutors are out of control, that the sentences that are being handed down in CFAA cases are extreme. And what I did was I tended to extract information from what I think is supposedly the best source for information about this, and that's the U.S. Sentencing Commission. And I'll explain where they come from in a moment. So turning back the clock a little bit, there was a day in which judges just got statutes and decided what the sentence would be. And it turned out that was problematic. In 1974, there was a study done of 50 judges in the Second Circuit, which is the area in the northeast of the country. And those judges were given 20 profiles of defendants who had, these were notional defendants with various makeups, but they all were given the same package of material. And they looked at how the judges sentenced those individuals. And what they found was great disparity based on race, gender, and region. So, for example, in one instance, you had a judge giving a defendant 3 years incarceration, and another judge, same notional defendant, giving him 20 years. Immigration violation, you had one imposing probation, you had another one imposing 3 years. The point being, judges left to their own devices were giving disparate sentences. And so the notion was there's got to be some way of helping to discipline that. And so this is what essentially now is the system. Congress passes a law, a criminal law, and says, for this crime, there will be a minimum and maximum sentence. Let's say a 0 to 5 is the sentence. So for like a 1038-5 offense, that is the range. Well, the U.S. Sentencing Commission was created, and it is an independent agency that is bipartisan in nature, that attempts to provide further elements for different offenses that help guide the judge's discretion in sentencing, and it creates a range of what would be, in an instance, an appropriate sentence. So it's essentially the law plus math, and the judge then applies that. And there's a complicated matrix that's applied based on characteristics that we'll get to in a moment. Can the judge sentence outside of that range? Well, certainly. There could be something called an upward or downward departure from that guideline sentence, but the judge would have to state a good basis for doing so. And again, this is an effort to get consistency into the system. The way this generally works, the way the guidelines generally work, is they take the seriousness of the crime, which is given a number, different offenses, different numerical value. You would then take into individual offender characteristics, the criminal history, let's say, of a defendant, and then any aggravating or mitigating factors which vary for different types of offenses and are all laid out. It's a book that's about this thick that's amended every year. So let's give this kind of a concrete application. Let's take a what is possibly a relatively routine CFAA prosecution. You've got a defendant, and let's say this defendant is not just a defendant, but a ringleader. And they, using their mad hacking skills, break into a network using some tool that allows them to crack passwords. And the resulting damage to the target is $50,000, which is actually high. The median amount of damage for a 1030 offense that was prosecuted in the last few years is somewhere around in the mid $20,000 range. But let's say 50 for this instance. And the charge was a 1030 A2 offense. So when this gets to conviction, the judge would then use the guidelines, and it would look something like this. There's an offense level of 6 that's assigned to that. You look at the fact that it was a certain amount of loss, and there's a table that assesses a number for that. The type of crime, there was an access device and a sophisticated means, because again, of those mad hacker skills. Their adjustment now down though, because in this instance, let's say the defendant pled guilty, which is what happens in about 93% of federal cases, and did so on a timely basis. But as an organizer, not just an individual, there was an increase in the sentence. The defendant, let's say this was a first-time offense, as is often the case with our defendants. And let's not give him a downward departure that is credit for testifying against any of his co-conspirators, which could be a bump down. Doing all that math, you end up with a sentence of somewhere around 18 to 24 months. That's the guidelines range. Now, is that what this defendant is likely to actually receive? It seems the answer to that is no. So what actually tends to happen, based on data from the Sentencing Commission for several years going, is the trend is that judges will sentence below the guidelines figure. This is for all federal crimes, starting off. And if you look specifically at offenses under the CFAA, in about half of the cases, defendants get a sentence within the guidelines range, and nearly the other half is a sentence below the guidelines range. Departures upward are rare, about 1% of the cases, and those are on the most extreme cases where a judge feels that the sentence does not adequately reflect the offense that was committed. But wait, there's more. In relation to other crimes, which is, I think, a fair question, how do we think about this? Well, it seems that if you're going to commit a securities crime, a healthcare crime, or an ID theft crime in comparison to a CFAA violation, your sentence is likely to be longer, either under the guidelines or as actually sentenced. So what I'm trying to convey is that computer security researchers are rarely prosecuted in the CFAA. Their average sentence for an offense of any sort, not a researcher, but of any CFAA violation, tends to be somewhere around 23 months, but likely less. And that generally a court is not apt to max out someone who has committed a CFAA violation, which has its problems in our view for deterrent value. Now, having said all this, and pairing that with my assertion that I don't think we're out of control on this and we're trying to responsibly exercise discretion, does that mean that we don't need to care about concerns expressed by people about the statute? And the answer to that is overwhelmingly no, and here's why. All it takes is one flogging in the public square to chill people's behavior. And so whether it is by misunderstanding or whether there is one instance out there that people have vectored to and have in mind, if there is actually legitimate research that needs to be done that is not happening because people think, right or wrong, that they may be in the crosshairs for engaging in that activity, we care, and we'd like to see if we can make some corrections for that in some form, whether it's messaging, whether it's in our efforts to tighten the statute, because again, we think it is important to have everyone on the playing field who can help us deal with what is increasingly really perceived as a very significant cybersecurity problem. So, I'm speaking to you guys. I get to provide you with perhaps a little bit of advice. Is there anything I would suggest out of this? The one thing I will flag is that the things I've been talking about are prosecutions. So if you think about the things we do in stages, you've got investigation, you've got prosecution, and you've got sentencing. Well, I've talked about prosecutions, very rare. I've talked about sentencing, not very long. What about investigation? And I think this is the hardest nut to crack for this reason. So our researcher is back. You've got your bad guy, and what are you doing? You're perhaps scanning. Let's say you're engaged in trying to find vulnerabilities in online services. You're going to scan a network, search for a vulnerability. Let's say you find it. You may launch an exploit to see if it actually works. You want to do a proof of concept and see if you actually get anything back. Here's the problem. For an investigator, there may be no difference in what you have done compared to someone who is actually intending for a criminal or malicious purpose to gather information from a remote network. And so what has happened is there are people who have had knocks on the door from the FBI, the Secret Service, or whoever, trying to figure out what's happening. What are you doing and why are you doing it? And I think this is, again, the hardest thing to condition, because I find it difficult to say that they're doing something wrong. In some cases, it is impossible to tell until you have that conversation or that face-to-face what is actually happening behind the keyboard. So I think there are certain things that you might consider that might help reduce the likelihood of that happening, or if it does, reduce the likelihood of that escalating in some form. The simplest thing, and probably the hardest to actually do, is there's a question of authorization. And obviously, if you have authorization, there's no issue at all. What we're seeing is a growth of coordinated disclosure programs. For goodness sake, at RSA, DoD announces a bug bounty program itself. We like these programs. We like these programs because they reduce the likelihood of there being some misunderstanding about what you can do or why you're doing it on a network. Now, I understand that comes with some constraints, and that's where there will maybe issues if, for example, someone is acting beyond the authorization that's provided for a coordinated disclosure program or a bug bounty program. We'd urge you to first get clarity and ask for permission rather than forgiveness. That will be a way of avoiding some problems. One word about vulnerability scanning generally. We're often asked, look, if I'm doing port scanning, are you guys going to come after us for a 1030 violation? And while this question is a little bit more nuanced than this, if you're doing port scanning and what you're obtaining is essentially the normal handshake type information that you would get with a port scan, no, we know of no criminal prosecution has ever been mounted on that, and the likelihood of such a prosecution based on those facts happening is extremely remote. Now, it does get more complicated with certain other instances. For example, taking Heartbleed. If you are shaping packets and shooting it at networks and obtaining information back and doing that repeatedly, there is a question as to whether there's a technical violation of that offense, but there are ways of avoiding that problem, which I'll get to in a moment. Mass scanning. Similarly, same rules. The fact that you're doing it on a larger basis does not trigger criminal liability unless you're doing it in such a way that it intentionally results in a denial of service attack, essentially. But assuming that's not the case, it is not per se illegal to do vulnerability scanning. Now, you may draw more attention, but I actually think the world has shifted a little bit on this issue over the last few years, that some years ago, seeing this sort of vulnerability scanning was itself seen as a precursor to some sort of bad attack that may be occurring. And I think people understand now that with all the security firms that are doing this now, that this is not per se an indication of any malicious intent. Critical infrastructure. If you are going to scan critical infrastructure, the likelihood of you getting contacted by someone, not surprisingly, is a little bit higher, because there are concerns about intentional or inadvertent efforts to breach these systems and cause any sort of problem. Obviously, doing so raises significant public safety concerns. Two things here. PII. This goes to the question of if you are somehow in a network and you end up with PII. The stockpiling of PII is a problem. We do view the CFAA as a privacy statute. The notion is you don't get to go into a computer and take someone's personal information. If you're a good guy or a bad guy, that's a problem. Even if you're a good guy, that's a privacy violation, and you should minimize that. So stockpiling that information is a problem because, again, our ability to determine whether you're doing that for purpose of monetizing it later or for a legitimate research purpose is very difficult to discern the difference between those two things. Threats and disclosure. So there is then the punchline of, after I've found the vulnerability, how to engage with the vendor, for example, who has an interest in the vulnerability. And there are ways of having that conversation that are more or less likely to result in problems. So if it's approached as a monetary quid pro quo, it's going to sound a lot more like an extortion attempt. And there are ways in which you can be careful that doesn't happen. For example, we did start a process about a year and a half ago whereby the U.S. Attorney's offices, before they bring an indictment, consult with my office in D.C. And we have a conversation about the merits of the case, and we provide advice on that. I've had at least one case where there was an interesting exchange between someone who purported to be a researcher and a company. The researcher said, I am normally your customer. I access your network, and I kind of wandered through it, and I found that you have all sorts of problems, and I can fix those for about $15,000. Now, there was no allegation that the person was going to come back and cause damage if he wasn't paid. And at the end of the day, after going through exactly what was said, we decided it was not an actionable offense. There was nothing that actually met the requirements of extortion was said that day. One thing that was very helpful for the researcher there, although I think he should have handled things differently, was the fact that the whole conversation was logged. And so we were able to actually look at what was said, what the exchange was, and how everything was framed. So we would suggest that to the extent that you can do these exchanges in writing, that's probably a good thing, having some records so that there's less misunderstanding and people aren't just relying on the recollection or the reaction to characterize what was said and what was done. The last thing I'll flag is the Cybersecurity Information Sharing Act was passed in December of last year. And it met with some controversy because some people thought it was an electronic surveillance bill. I think that has since quieted. But one thing that I would flag for you folks that I haven't actually seen discussed is that there's stuff in this act for you. In particular, I would say the information sharing provision. What it does is it authorizes the disclosure of information, the sharing of information between private entities, notwithstanding any other provision of law. What that means is it overrides every other law. That if you are sharing information for a cybersecurity purpose from a private entity to another private entity, you're authorized to do so. And for you, those of you who work for companies, I would suggest you might want to have your counsel take a look at this statute to think about how it might apply to the work you do. So, punchline. We like you guys. We get that what you do is important. We are not targeting researchers, and we want to encourage you guys to do what you do and to do it well. We're trying to figure out how to not criminalize trivial conduct that captures things like what you do and what other people may blunder into. And we do think that some precautions will make hassles with law enforcement more likely, and these are things that we think that you could implement fairly easily. And we'll continue to work with the community to figure out how we can do those things. You can contact us. We have resources online. If you go to our website, we have about 1,000 pages of manuals on issues like prosecuting computer crime, on searching and seizing computers, the laws that might apply there, and prosecuting IP crimes, which includes discussions of how laws like the DMCA are applied. So I encourage you to use those. And with that, that ends my presentation. I'm happy to take any questions. As I mentioned, I'm happy to also hang around if you have any questions that you want to ask afterwards.
If you have a user that doesn't follow the policy that you have at the company, it causes over $5,000 worth of damage, does that become a federal charge?
Right. So if it's a violation of the terms of service and they cause over $5,000
Yeah, it's
of
like
damage,
our policy, and it's an employee that doesn't follow our policy in the company. And
Right.
it cause over 5,000.
Right. So right now we're at an inflection point in the law. I mentioned that the exceeding authorized access provision on things like terms of service has been the subject of some controversy. We currently have 3 judicial circuits who say affirmatively that that is not a violation, and that essentially anyone who has lawful access to a network and then uses it for another purpose, misuses it, cannot be pursued under the CFAA. We have 3 other circuits that say affirmatively, no, that is actually a basis to do so. And so we actually have a split in different parts of the country on this particular issue, and we're trying to work with Congress to resolve that. We think that there should be a violation of sorts, not for commercial agreements like a MySpace agreement, but for an employee agreement where you have informed your employee that there are certain things you are not allowed to do on the network. We would say that should be a violation of the statute.
So you mentioned in one of your first slides that you guys have thought about applying some limiting principles to the statutes. However, I think the biggest problem that most of us in this room have with it is that the CFAA is relatively open-ended, right? So there's not a whole lot preventing the Justice Department. It's not obvious what the limiting principles are currently. Do you believe the Justice Department would do that willingly, or do you believe a case going in front of the Supreme Court would be required to apply a limiting principle by precedent?
Right. So, the 3 amendments that we were discussing about, making sure it's in furtherance of another felony, those are things the department is proposing. So those are limiting principles that we think are workable, would allow us to do what we do and need to do to go after bad guys, while carving out some other activity that should not be criminalized. By and large, trying to amend statutes by judicial decision is hard. It's a little better to be able to sit down with Congress and figure out what is the right answer. We're trying to do that now. I know also there are folks in the community of computer security researchers who are also engaged in Congress. There are a couple of senators who are particularly interested in this area, and that's an ongoing dialogue back and forth. Any other questions?
You mentioned an example where there was a researcher who handled things maybe less professionally than they could have. Could you provide a successful example or talk a little bit about how to bring up those, if you do discover a vulnerability and you're trying to work with the company in a professional manner, how you would go about doing that?
Right. So, for example, having a plan for what your research is goes some distance. It's helpful to be able to say, if there's a knock on the door, well, I'm actually engaged in this. Here's a research plan. If you're working with a company, this is something my company is sanctioned. That sort of thing helps to characterize it more easily as not something with malicious intent that's intended to monetize information for an illegal purpose. I actually think one of the more helpful things is just actually being willing to have a conversation about it with an investigator. Obviously, it is your right not to if you choose not to engage with an investigator, but the problem is that investigator is trying to figure out what's going on here, and if there's a fairly readily available answer that you can furnish, that helps. One of the reasons why we exist is we also get calls from our investigators across the country who have questions. Let's say that you're doing something that seems odd to them, but they're not particularly conversant in computers. Well, we have people who actually are more comfortable with computers in the sort of research you're doing, who could maybe explain to an investigator why it is certain types of conduct is being engaged in by a researcher. But I do think having something like a plan that is in some form documented or public is very helpful.
Other questions? Yeah, I had a question about, it's been an issue since, the E911 document hijacking of how value is assessed to, say, stolen documents or to cases. And, this is basically the E911 document was like a classic case 20 years ago, and it's still an issue today of, there was a case worked up for, intellectual property that was stolen, and then the value that was assessed was basically you asked the people who stole it, how much was this document worth? They said hundreds of thousands, and so a really big charge is brought up, and then after the charge, hits, they found out, oh, actually, you could get this document for free if you just called a 1-800 number. And so we still sort of have this problem about how you weigh that. I guess it's less of a question, but it's kind of a complexity.
Yeah, so in complete candor, I think valuation of harm is among the hardest things that we have to engage in, because yes, sometimes you have very disparate numbers. You have a company that will say, this resulted in this much harm because I had to invest this much in R&D to develop this thing. Does that go to it? I also had to fortify my network in this following this incident to prevent it from happening again. Is that valued? I can tell you that often the former may be part of the valuation. The latter is not, under things like the guidelines, which set out, you don't get the value of improving your network. It is actually the damage of returning it to the status quo ante where it was before. But yes, this is always a contested part of any criminal prosecution, because the values matter a lot in the sentencing phase.
Thank you. Other questions?
So sort of as we progress in time, I mean, previously having an American having access to telephone was an inalienable right as an American. Now having internet access is that. Does that affect, I mean, if it's an inalienable right that I'm allowed to have internet access and so therefore I am allowed to be on the internet, does that affect law at all? I mean, and maybe not now, but in the future, whereas there is no term of service because it's my right to be on the internet and to access it as I please. Is that, I mean, do you see that ever becoming either a defense or making the law not stick as well?
So I'm going to be a Weasley lawyer here. First, I'm going to start with saying, when we speak of rights, we tend to look for an authority that says, I affirmatively have the right to this thing. So we have certain inalienable rights, right? And we have those embedded in our Bill of Rights, for example. I wouldn't say that we have a right to the internet. I do think it's become so indispensable that it is very difficult to operate in a modern society without internet access. And so I think for policy reasons, we should have policies that encourage and acknowledge that this is something that will be generally available and should be available. I'm not exactly sure how that will affect the criminal laws we're talking about today, in that there are other statutes like under the CFAA damaging computer systems or rendering them unavailable. So a DDoS attack, for example, that removes access or prohibits or prevents someone from getting access to the internet. So we have statutes that apply to that. I do think that we're going to see more of concerns about impairment of access to either the internet or probably more likely devices. One manifestation of that is what you've heard a lot about in the last couple of months is the ransomware concern. We see that as likely expanding. We kind of predicted that last year. One of the reasons why we took down the Game Over Zeus botnet, which was being used in conjunction with CryptoLocker. So there are, but a slightly different issue, but I do think the fact that this is all becoming so interwoven in the way that we have to operate will have consequences. Not a futurist, so I'm not really good at predicting those. Again, knuckle-dragging prosecutor. Thank you.
I have another one. I've managed to forget it. Oh yeah. have there ever been like defenses that have put on by people who are charged, saying something like, "Yes, I found this," or they would not willingly admit that they did it, but the product that I was going against, the network that I was going against, was so bad that they say, "Oh, you charged $5 million worth of damages," but the person, you can come back and say, "This product was so bad and was intentionally bad." Well, I mean, have you ever seen that defense and saying, like, you're saying this costs $5 million, if you had, hired one more person, you wouldn't made such a crap product?
Right. The only thing I would say about that is, the one thing I didn't get into in this talk is the fact that the CFAA has a civil cause of action. So, this is the way that we would view the law and the way that we would use it. There's concerns, I know, about companies using the statute to go after researchers, which are not something that we can as readily address. In the criminal system, what you just laid out was not exactly what happened in the Auernheimer-Spittler case, the Weave case. It was, though, kind of at least a tertiary issue where the claim was, look, how can you call this unauthorized access given the way in which this information was available? We didn't get a final word on that, in that what happened was, after the convictions, that conviction was overturned on appeal for reasons not having to do with the nature of the crime, but rather for jurisdictional reasons. It was brought in the wrong place, and the government hasn't re-brought that case. So we don't have a ruling on that. That is the only case that comes to mind, though.
Yes, I was wondering, you mentioned that there was that 8th grader that was prosecuted under the federal. So was he prosecuted under the federal? Did the state bring a federal crime against him, or was somebody just mistaken?
Oh, to be clear, so the state authorities can't bring a federal charge. They can only bring charges under the state law. There was an arrest under state law by the Florida authorities. No federal charges were brought, but the state authorities did bring some sort of charge. I can't tell you what the disposition of that, whether they went through with the case or not, but just flagging it as an example of something that wasn't us, but other people for some reason thought was worth.
All right, thank you.
Sure.
What do you think about self-defense through the internet? Let's say I'm a person and then my website's obviously getting spammed or trying to get attacked. Well, do I have every right to attack back?
Right. So this is the Hackback Act of Defense Countermeasures. It's called many things in many different places. I can tell you what our view of that is. It is, by and large, it is not a good idea for the following reasons. Usually, obviously, anyone worth his or her salt is going to proxy through another network. So usually your activity is going to be directed towards what's likely to be a compromised server of an unwitting, innocent party. Two, even if, for example, we didn't come after you, as I mentioned, almost every state has a hacking law. If it's in a foreign jurisdiction, most states also have one, or most countries also have one, so you have liability there potentially. There's also things like, we did have an instance in which we had to consider whether to take action against a party who decided to follow back and look into a network that he believed his information had been exfiltrated to. What he didn't know was there was an active investigation of the targets, including that site, and the putative defendants noticed his presence there, shut down their operation, and moved. So there was damage done to a law enforcement investigation that was intended to protect more than just that person's network, which is something you can't know if you're going to engage in. So there's a variety of reasons why it's a bad idea. I can tell you it is unlawful. There is no self-help provision in the CFAA. So there are legal risks, and I think there are reasons why it's just not good policy.
Yeah, I would just like to have clarity on a statement that you made earlier. You were saying about that you don't see that there is a right to have access to the internet. Like with television, public access is required that there has to be like a public access station as something that's a government regulated communication, why would you have the statement that as something that's government regulated and as a citizen that we shouldn't have a right to have access to it?
Right, and again, this maybe I'm, as I mentioned, a lawyerly answer, but the fact that something is regulated as a public utility, as I understand the FCC is starting to look at the internet as, does not necessarily mean that you have a right to it. So if someone is without that there's an affirmative obligation for the state to furnish access. So if you petitioned the government and said, I don't have internet access, you must provide it to me, I don't know under what authority you'd make that claim or what obligation the government would have. That's separate from the existence of such a thing and the need to make sure that it is properly regulated, to make sure that it's not creating undue hazards or harms, I think is a different question. And I think that is one of the questions that may be coming up soon. There are questions as to how far the FCC is going to go in looking at the internet and regulating it. Still unsettled. I don't think we're at the point where they're saying we are going to regulate this thing just in the exact same way we are doing other utilities. But I think that's an ongoing policy question, and I think that's only going to increase for the reasons that the other person indicated, that it's just become so interwoven in our society. And let's see, with that, I'm way over. I'm happy to hang out if you have any questions that you wanted to pose, but thank you very much for your time, and I hope you enjoy the rest of the conference.